Please be seated. Proceedings are resumed. Does any other member wish to speak? I call on the Honorable Leader of the Opposition.
Mr. Speaker, no doubt in listening to what the member who's responsible for this bill had to say, some of the things that he has said we've been concerned with for many years. But I am somewhat concerned about the bill nevertheless. Mr. Speaker, statutory authorities and government companies were created to operate in a quasi-public-private sector fashion and remit a dividend to the shareholder. Several of the statutory authorities, specifically the regulatory authorities, are doing that, and so their performance against ownership agreements can be measured. These authorities, excuse me, Mr. Speaker, these authorities also file required annual reports with audited financials. Now, I heard the member say that there was proper consultation. Contrary to that, I was told there was no proper consultation with the statutory authorities by the framers of the bill. Yes? And they say the matter was raised with the caucus sometime in August in 2015 by the regulatory authorities, whereby a PowerPoint presentation, was given with options. And Mr. Speaker, I'm hoping that the member listens, because these are things that I'm told. I don't know what go on in government. I don't get invited to meetings. I'm only told after something has happened in 99.9999% of the time. So what I'm saying here is things that I've been told as the leader of the opposition, and I'm hoping that the member responsible for the bill will be able to shed some light on these things. They say that at that time in August 2015, a PowerPoint presentation was given with options that could open the door for discussions with Cayman Islands government, and assurances were given that the Deputy Governor would be directed to have meaningful consultation with the statutory authorities before further consideration would be given to the bill. But such consultation did not happen. This bill, Mr. Speaker, seeks to create new legislation for governance when I think, and this is some of the things that I am concerned, and they can answer, that there is existing legislation that addresses most, if not all, of the various issues contained in the bill. The Public Service Management Law and the Public Management Finance Law. And I'm wondering whether that would not have been a better way to go, rather than trying to enforce those existing new legislation is being proposed. I guess, Mr. Speaker, that much of this is about compliance. That's what the bill seems to seek to do. I am told that one of the auditors felt or rendered an opinion on the matter and seems to be not in agreement with the new legislation. Now, that could have been the auditor gone, and if you didn't listen to him, I wouldn't hold that against you, my son. He was the biggest liar that ever came to this country. But you take note of what they say. But I wouldn't take nothing of what they say. Too many things they try to do this country, and if you had left it up to them, the ministers wouldn't have had no say. Somebody else would have had all the say. I know that, whether you all want to say so or not. You never mind about how I talk. I don't know how to talk out of both sides of my mouth. Only lawyers can do that.
Through the chair.
Only lawyers can do that. That's okay, Mr. Speaker. You stay out of it a little bit, and that means him have it. Only lawyers sitting down here can do that good. Talk out of both sides and about. I'm not me. I'm too much a layman for that. Don't know how to do it. But I only say that to the member responsible. I wouldn't listen to him either. But they said that they felt that there was sufficient existing legislation to provide good governance. The introduction, Mr. Speaker, of new legislation raised questions as to how these measures will be enforced if existing legislation is not already being enforced. Would it mean oversight by core civil service personnel? And if so, is this not counterproductive to the spirit and intent of the statutory authorities legislation? I would think the statutory authorities, most of them, and all of them have had their struggles and still do. But we can say that they have been efficient, and especially 2 or 3 of them are remitting dividends to the government. I think Monetary Authority do. I think what Port Authority do, and I think Civil Aviation do. If there are huge issues, and as I said, I listened to the member responsible, and some of those things we have been concerned with. If there are issues, though, with individual statutory authorities, would a review not suffice, beyond a review be undertaken that is specific to those issues on the statutory authorities, rather than a new complete setup? The various industries represented by regulatory authorities are not all alike, and they require individual and customized, as far as I'm concerned, approaches to human resources, operations, on and on. You could go with it. I'm waiting to get into committee to see some of the matters, whether it is a broad brush cookie cutter approach or whether it is directed elsewhere. People throughout the country feel, and simply, and this is how matters can be twisted. There was an article written which talks, I think the Premier might have been mentioned, but definitely the member, talked a lot about the salaries. And the people got the impression from that article, because we didn't know anything much about the bill, people got the impression that, and I'm not, when I say people, not members of this House, I'm talking about general people talking to you, that this was about cutting back on huge salaries and not anything much, and other things were just thrown in, but the way to control the salaries was to get this legislation. But I would hope that that's not the case, that because there are other things that matters that I believe the government, central government, needs to know more about. Would it not be a better approach, Mr. Speaker, to review, and perhaps maybe this has been done, all the statutory authorities? Maybe there are some that probably should not be categorized as statutory authorities and might be better off back on the central government. That is something that you might want to look. When you get in the committee, we can talk further. There are some that can. Carve-outs for the regulatory statutory authorities, especially those that regulate to meet internationally mandated standards, and there is at least, but the more serious one is the Monetary Authority, Macy. Port Authority has now a lot of international regulations that they have to follow, and civil aviation. I don't know so much about the Airport Authority, but I know that maybe most of them is, but certainly some more than others have to meet the international mandated standards and requirements. And these are the lifeblood of this economy and should be recognized for their industry status and allowed to be managed in the best interests of their individual industries and resultant economic benefits for the islands. We've always heard about political bias, and I'm concerned that the law might be putting that in cabinet, in some instances, will result in the compromising of regulatory objectivity because politicians see it different from management. And we don't want that to compromise the need for independence, to satisfy those international mandates. And I don't hold the belief entirely, member, that it is, you simply just introduce core civil service standards to those bodies. Might not be suitable, as I say, because they're not all alike. Now, the bill calls for salaries to be determined by cabinet rather than through open market industry comparisons, so that the statutory authorities can ensure the best human capital resources available. In the attempt, and I know what the member has been saying because we've heard that all along. I mean, the Port Authority contract was signed the day I was being sworn in 2009. So, yeah, the government, the cabinet, this cabinet is not taking any chances. They're going ahead and putting the law. winds it way back to the government, but the independence is still there all along. That's what was happening. Independence is still there. But we have to be careful that it don't undermine the statutory authorities, especially those in highly specialized industries with internationally scrutinized mandates to ensure that they have adequate, qualified staff. Because in central government, you have room to move around in a time of crunch. I mean, I don't know of any other time in this country that we went through a situation or situations as we did between 2009, and perhaps the government that went out had some of that to deal with. But I don't know that I've ever heard about a time that we've had such a confused, restricted position to be in at that time, because we could not get staff and we needed staff, much to the chagrin of the private sector. The private sector is one of them that cusses government, but yet they want all the services. I put this away about the government when about the opposition when I'm in government, that the ones that burn down the fire station is the one that stand on the side cussing government because the fire truck never got in time. You cannot go by them because they believe that all the work that we are producing as a country and the civil service is producing for this country, that can be done by 5 or 10 people. Oh yeah? They don't know how to operate like that. And if they tell me which country can do it, they show it to me. Some of the best run countries can't do it. So I wouldn't pay much attention to some of what they say. And you see it in headlines, you see it in editorials, you hear from the Chamber of Commerce, but they're the ones that want all these things done by the civil service of the country. They want all these things done by the statutory authorities in the country. And those authorities have to have adequate and qualified staff with specific technical training and knowledge that could negatively impact the safety of human lives if it is not there. And it's not as easy as some might want us to believe. It's not as easy. All of us that is in some managerial position at some point know that. Easy to talk. Candidates out there saying all sorts of things. Easy to talk. Get the job done. You find out it's much more difficult. Liability was another aspect, issues that I had some concern with for the statutory boards, directors and staff. People complain that we have to put in that kind of legislation. But we're not paying no board members no $15,000 and $10,000 and $12,000 or $5,000 to sit there a month. All the boards are practically voluntary boards. Gets a minimum of maybe $250, a maximum of $250, if that. I don't know if it's that. For a meeting, and plenty of them are business people, and you have to have them on as much as they want to talk. You have to have them on because they know the business, they know the position in the country, they can make decisions. You can't put people there that don't know. We've done that in the past. The new paradigm it has to be different. So I wait on the minister, on the member responsible for the bill, when he rises to explain, and it's not there, but certainly in committee. In a recent article, Mr. Speaker, all kinds of things have been said about the Port Authority, but the history of the Port Authority contradicts what they say in that article. And we find too much of that. In fact, I'm happy for those foreign nationals who are reporters that will take the time and take up the phone and say, can you give me a bit of your knowledge or the background to this? Because far too much is being written and they do not know the background. Who? I don't know, but he might be others. What about that one that's on the news, on the net? You don't want, they're like Amjad, terrorists. Mr. Speaker, just a little bit of history, because you as the first member from Georgetown said, the three of us been here longest, and we know a lot of water under the bridge. When I took over in 2000 as minister, I was shocked that the 2000 government had taken our position there to discover there was so little cash in the bank accounts of the Port Authority I'm talking about. And the then financial controller informed me that that position was untenable, but it had existed for years, but we didn't hear anything about it. And needed immediate attention, and that was done. It was then I realized why in the past year, near to each month, and there was an intense scramble to collect cash from creditors to be able to pay the monthly bills. That was back in 2000. The port was indeed operating on a month-to-month cash basis, and over my years as minister, the average year-end cash in the bank was anywhere between $3 to $5 million. At no point in my years there were operating revenues less than operating expenses. But the port financials, Mr. Speaker, are based on the accrual accounting principles, and non-cash items like the depreciation, something that I didn't understand why we was saying you had all this money that you couldn't take account of, or you didn't have it, something like that. It was confusing to me, but I'm not an accountant. And the write-off of assets, those things are considered in the financial statements, unlike central government financials. And it is true that with the inclusion of those items in 2009 and 2010, the port made losses. Those were large sums. The reason at that time, as I recall, was twofold. First, the recession that began at the end of 2007 was felt hardest in 2009 and 2010, and that was combined with the write-off of assets destroyed by Hurricane Paloma that hit the BRAC in 2009, and those had to be taken care of. So, Mr. Speaker, the port made losses, not cash losses, in 2009 and 2010. The bank cash balances at the end of 2009 was $2.5 million and $1.17 million in 2010. And between 2001 and 2005 and 2010 to 2012, the port made profits. Why? I don't know this, and I have to ask this. Why is the current government board, who took office in 2013, continue to insist that the Port Authority was in a financial problems in 2013? I would like to see the proof of that. And I hope it's not just being mischievous, an attempt to satisfy anyone's political and personal egos. But from 2011 and onwards, the port again made profits as the economy improved. The port never required any cash subsidy from the government, such as Carl has to do, and Macy and others. The port has contributed some of the highest cash dividends to the central government of any statutory authority. And I should also point out that there was, from what I understand, there was no review of the performance of the last port director by Deloitte. In fact, they started their ongoing review after he left the port on the 15th of February 2015. So it is my understanding they are still trying to find some kind of smoking gun. I don't know what they were looking for, but so be it. As I speak, 2 years and hundreds of thousands of dollars later, it has been suggested finally now, though, but informally, that the port is indeed one of the best well-run in the Caribbean and comparable to any other port. If information is correct about the review, though, by Deloitte, Mr. Speaker, prior to the departure of the then director, I would submit it was done in not such a good manner, but without a proper contract, and that needed to be brought to light. And in keeping with this, because you're asking how I'm debating, but the fact is this Port Authority is part of this review and will become part of the new makeup. And after seeing 2 articles, I had to make these points, Mr. Speaker. So, Mr. Speaker, good things, because I do recall that the port was severely damaged with 4 hurricanes: Ivan, Mitch, Michelle, and Paloma between 2004 and 2009. And we were able to rebuild in record time. After Ivan in 2004, the port was partially operational within 3 days. And in 2011, the port was ranked by the Caribbean Shipping Association as the 2nd most efficient cargo handling port in the Caribbean, and just behind Kingston, Jamaica. And we implemented also the board's policy of cargo night operations in 2002, when we were told that you couldn't do it. It couldn't be done. 2002, Mr. Speaker, then before my time, it was deemed impossible. And that single move propelled the Cayman Islands into the top 5 cruise ports in the Caribbean region, including Mexico, and we did it without cruise piers. This directly resulted in the handling of an additional 1 million passengers per year. That was resulted in an additional $100 million annually in direct and indirect cruise passengers revenue into the economy. Mr. Speaker, in the new makeup, we cannot forget where we come from. We have to take cognizance. We can't forget people that have helped us get to better positions. I am not, as I said in 2013, I'm not standing up in any corner of this country, whether in this house or otherwise, to be a stumbling block to the government so that we can't get ahead. We've had too much of that in the past. I could not do to anyone what was done to me. Let's not start now. I see your hot sign over there. Mr. Speaker, I'm going to wait till the member, either on the floor or in committee, address some of the things that I've talked about. But I'm not saying as of now that the bill has my support. I want to hear answers to some of these other things. I know and I feel with the government on some of the things the member has said. But we have to bear in mind some of those things that I've said too. And if the bill covers those things, I know he has had, I really call this government, the amending government, because they can bring a bill and amend it, Mr. Speaker, but they got 14 and for this bill, and I trust that some of those will impact some of the items that I've talked about. Thank you very much, Mr. Speaker.
Does any other member wish to speak? I recognize the honorable member from Northside.
Thank you, Mr. Speaker. Mr. Speaker, I have always advocated for and supported a overarching governance bill for statutory authorities and government boards, because I believe it is necessary to put in place some common standards on governance across not only statutory authorities, but the boards that are appointed by government under certain other legislation as well. And, Madam Speaker, Mr. Speaker, sorry, in keeping with the request of the Premier, as he asked intimated under the debate of the Legal Practitioners Bill, that they will bring imperfect bills here and expect us to file amendments to approve them. I've spent some time on the bill and I've filed 28 amendments. Yes, but I noticed that the mover of the bill, the Deputy Governor himself, has filed some 14 as well. So hopefully not too many of those of his amendments correspond to mine, but I believe we can make the bill something that we can live with if we make some amendments. Because, Madam Speaker, when I talk about governance procedure, I'm talking about putting in place policies and procedures that ensure that proper governance occurs. Governance should not be relied upon for personalities, whether ex officio or otherwise, to be put on a board to ensure governance, because that can't work. And I will deal with my view on the KFA fiasco a little bit later. Because, Madam Speaker, good governance at this stage of the history of the statutory authorities should not be about clawing back authority from the boards and bring it into the central government, or by providing for ministers to appoint their chief officers to the board to bring them back the information that what goes on at the board. Kind of like a stool pigeon type of thing, where they can make their suggestions at the board level. They can influence decisions of the boards, but there's no record that they did because they're not voting members. What should be in place is that the ministry, either through the minister himself and cabinet or the chief officer, should put in place written directives to the board so that we can determine who wanted what done. But when you put them on the board as ex-official members, they sit there in their cozy little way, right? Everybody else is intimidated by the mere fact that they are there and will not normally say things that they should say because big government is present. And then when things go wrong, they say it was the board's fault. Good governance should not be about providing through legislation additional authority for the chief officer or the minister. The enacting legislation should provide the authority to the board and the board delegates that authority to the chief officer and management for implementation and achievement outcomes. The minister should not be in a position to counteract the authority that the legislation gives to the board by having his chief officer and his chief financial officer present at board meetings. And just to deal with the KPA situation, it wasn't the board chairman, as reported in the press, that signed the check, was the chief officer. We have investigated for any signs of corruption, and they have been exonerated. That's a good thing. But, Mr. Speaker, what we didn't investigate for was misfeasance, malfeasance, or just maladministration. Because sitting on the board wouldn't prevent that problem, because that decision was made in the ministry. So, Madam Speaker, for instance, this bill provides that if there is not a representative from the minister, either in the chief officer or his or her designate on the board, the minutes should come to the ministry. The policies and procedural manuals should say that the minutes, once confirmed, should be forwarded to the ministry, whether anybody's there or not, if the ministry is interested in knowing what's going on at the board level. But you see, if they have that person there, they don't want the minutes. They can rely on what they come and say. And that's not good governance. And as recent, Mr. Speaker, as the latest Auditor General's report that we tabled, it was pointed out in the hearings by the Auditor General and the staff that appointing the chief officer and the chief financial from the management, the CEO rather, and the medical director from management, and the chief officer and the chief financial man on the board was not good governance. For the same reasons that I'm talking about. And when we tried to investigate how policies and procedures was handed from the ministry and the chief officer to the board chairman, we were told, well, I go up to the office once every 3 months and we have a little chat. Now, that's not the way it should be done. And when we talk about the HR functions and all that, the bill should say that the board must put in place a proper HR manual and procedures that corresponds with the provisions of the public management law and the public finance management law. And they should have to abide by those policies and procedures. And those policies and procedures should come up to the chief officer to ensure that they comply with the legislation over which these people should be governed. It's just like we make all kind of fancy maneuvers in the bill to deal with salaries and remunerations and pensions and health insurance, which, in my view, compounds and further complicates what exists. That policies and procedural manual should simply say that the benefit package that civil servants get, i.e. for health insurance and pension, those people get the same benefit. Because it has to be more sensible for government to have all of the people in the statutory authorities subscribing to Cineco than have them subscribing at more expense to private healthcare providers, and then when they exceed the benefits of that plan, they fall back on government, especially when they retire. And as I pointed out in Cayman, in the case of one authority, they made that move approved by the board and cost the board $83,000 CI for the year. So, Mr. Speaker, I heard the Deputy Governor say that he had reviewed the statutory authorities looking for the word Caymanian. But Mr. Speaker, we're the only country in the world that recently we have to write in what our citizens can get. Everywhere else in the world, it assumes that the legislation is for, by, of our people. But we have so capitulated to foreign expertise and foreign rule that we believe we have to say that you must give Caymanians priority. That should be a given. And any variation from that, because remember, Mr. Speaker, the immigration law is quite clear. The immigration law says every single job created in this country belongs to a Caymanian. That's what it says. Unless you can prove that you have made every effort, and it goes into great detail of how we do that, to find a Caymanian. You got to advertise in the paper, you got to do all sorts of things. And if you don't find a Caymanian, then you can ask for a permit. Somehow that's got turned upside down. And we got to try force a couple of Caymanians in amongst the work permit holders because they get them so easy. Right? Now, Mr. Speaker, there's a couple of things in the law that I have filed amendments to correct. I will offer to sit down with the deputy governor and go through them because I believe that some of them are very important. For instance, a board shall have the following specific responsibilities: to ensure that public authority communications with ministers, members of cabinets, and other stakeholders effectively. But it doesn't say in writing. And as Mr. Harry McCoy used to tell us civil servants way back in the early 70s, if it ain't in writing, it didn't exist in government. Because anybody involved in these communications and is not prepared to put it in writing should not be communicating. Because you have to be able, Mr. Speaker, to trace these directives, to trace how these decisions are made, to trace who's recommending these decisions, and under what conditions they're being made. You know, Mr. Speaker, one of my favorite subjects in postgraduate school was decision making. And I started off with the Harvard Hamilton 14 steps, went to the Dornblaser 17 steps, so 7 steps at the University of Minnesota, and I had now distilled it down to Ezra Miller 5 steps. Right? And I respect anybody who makes a decision that I can audit. If I can see how you got the decision, I respect your decision. I mightn't agree with it, but I respect it. Because you might have had information, you might have had resources to address the problem that I wasn't aware of. So I would have come to a different decision. But when you do it in these little meetings once every 3 months, over a cup of coffee or tea, there's no record of it. And we have to ensure that if we're talking about governance, that there are proper, established lines of communication, that it must be in writing. It must be from the ministry responsible or cabinet to the board chairman, and the board should communicate those instructions to the chief officer in writing as well. And the board should evaluate whether the chief officer has achieved outcomes that that directive is related to, and report it back through the minutes to the ministry. But you see, Mr. Speaker, all these things requires work and effort. And it's easy to simply say, oh, well, I talked to the chief officer at a cocktail party, and we agreed to this and get it done. Or, as I said earlier, you put them on the board, the minister or the ministry wants something done that is not really, don't want to put it in writing because it's kind of borderline in terms of the job of the board or the authority. So they send them there and they shoo-shoo to the person beside them and they get it passed, but they have no responsibility for it because you can't trace the fact that they were involved in the decision making. And Mr. Speaker, I talk from experience. I've been on these boards. I set these boards up. And I know how a lot of them function. The other thing that I would like to see in the bill, I would like to see that all the board meetings are held in public. Because if we want transparency, we want scrutiny, and since they're adopting the recommendations of the Auditor General, that certainly was a very important one of the Auditor General. Can't agree, Madam Speaker, that 3 board members should be able to call a meeting. That's okay if it's a 5-person board. But what happened in the case of the Health Services Authority, we've structured now, and what is 11 people or 12 people on it? 3 people shouldn't be able to call a board. So the bill should say the majority, just like this Parliament. No 3 people up here can't call a meeting. We can have a majority. Because you must have a majority so that you can have a quorum for the meeting and you can look, and the decision is properly done. And Mr. Speaker, we're getting in trouble again with this bad faith thing. No personal liability except for negligence or bad faith. I don't know how you fool bad faith. If we have proper governance, that clause can be deleted. Because people sitting on these boards should accept the fiduciary responsibility. If they're not prepared to accept that, they shouldn't appoint them to the board. Because this not 1950s and 1960s Cayman. It is plenty of well-qualified and experienced persons that you can put on these boards that can ensure that they respect and adhere to their fiduciary responsibility. So why are we letting them off the hook? Can't agree, Madam Speaker, with the appointment and responsibilities of the chief officers, public authorities shall be appointed by the board after consultation with the responsible minister, I think, in terms of the chief officer. Again, Madam Speaker, why are we confusing authorities? Why are we mixing these authorities? The board should be charged through a proper procedures and policies issued in writing to follow the standards of the civil service. But if you can have the board do it, but the chief officer can do it, who's responsible? In the final analysis, the board chairman can simply say, well, I wanted to appoint Joe, but she wanted Harry, but I think Harry could do the job, but since she said it got to be Harry, Harry it is. We don't need to create that kind of double confusion in standards. Give the board proper directives on the proper policies and procedures and have them function like a board. The chief officer has to work for them, not for the chief executive officer has to work for them, not the chief officer in the ministry. Because who is the chief executive officer going to be more loyal to? The board or the chief officer in the ministry who can communicate with him? And there's no record of it. The chief executive officer should not be interacting with the chief officer in the ministry. We have to delineate these clear lines of authority and responsibility. They must be under the control of the board, and the board must be responsible to the chief officer and or the ministry. Because how are we going to hold the board responsible for the outcomes? Because if you're involved in picking who their chief executive officer is, who's the only person that is going to be in a position to implement the administrative and make the decisions that needs to produce the outcomes. And there's far too much of this going on where the chief executive officer believe they have a special relationship with the ministry and the chief officer, and things are going on that the board don't know about. The board, when recruiting the top level of management, should have a panel, but it shouldn't include the chief officer. The directors and policy will say you must have a 3-panel persons. Let them decide who it is. Get people from in the private sector. But don't let the chief officer dip their finger in what's going on. Shouldn't have to submit the job description to the portfolio of the civil service to evaluate the job description. That's the function of the board when it comes to the top level management. It is the function of the chief executive officer to everybody below them. They're the ones that are on the ground. They know the resources they have. They know what their functions are supposed to be, provided it has been properly communicated from the board. Then you got 26.3. Before making an appointment, a board shall consult with the minister or official member responsible for the public authority. Again, you're confusing accountability and authority. And I don't know why we need all of this variations of, and we're looking to reinvent the wheel and formulas for salaries and remuneration. It should fall within what's established for the civil service. Not just the salary brackets, but the benefit packages as well. Health insurance and pension. Because this country is facing right now a very serious problem. We have allowed many of these statutory authorities to have private sector health insurance. Now they're 60, they can't get no coverage. But the one how to solve that is to put them in Seneco in the government program from the day you employ them. Because they're actually contributing towards it then. But now they all expect, and they're all coming to people like me and say, boy, I'm not going to provide for us, because we're 60 now and the private sector insurance don't want to insure us, so you have to make sure now that you all put in place so that government will take it in Seneco. Because although they come here and they tell me in finance committee that they have retirement health insurance built into their plans. But if I call the CEO myself and say, I hear you're offering retirement health insurance now, people over 60, I won't come in. Oh, no. I say, well, this is what I was told. One person out of 40? And then I get no more. You see, if you had a policy in place that said all employees of statutory authorities must have the same health insurance plan as the government, whatever that comes out to be. Simple. Oh, I know. We have the same problem with pensions. Some of them have private pensions, right? When they get that wonderful, remember that thing that solved all problems of pension Cayman, called defined contribution, that con job that was pulled on this country. So hold on a little bit and not start to reap the benefits of that con job yet. But they're coming, Another 5, 10 years, you can see what happened to them civil servants, because if it's a proper defined contribution, they got another money. Because their contribution is not based on any fixed percentage of salary from retirement to death. Defined contribution is defined. You put in 5%, I put in 5%, you get a quantum, and you get annuity, and the current law says you get $1,000 a month. Now you're asking somebody who works for statutory authority, who's living on $10,000, $15,000 a month, to suddenly live on $1,000 a month as a retirement benefit? It happen. We still have some time, I believe, if we use this legislation to bring them all under, and we transfer them out of the private pension plans that they have into the civil service plan. Because according to the Chamber of Commerce, we have portability, right? Well, you either can do that and get the benefit of their contributions, or they can wind up as wards as the Social Services Department to get the $550 a month, and you don't get nothing at all. $29.3, again, the chairperson shall consult with the relevant minister or official member prior to dismissing the chief executive officer. Again, that's unnecessary. The policies and procedural manual must clearly delineate how and why a chief executive officer is terminated. Why you want to complicate this? Because it don't say. Look at what the law say. It don't say the chief officer in the ministry or the ministry now. It says the minister. But according to the Constitution, ministers are not supposed to have nothing to do with personnel. Right? That's a statutory, I was told this morning. Huh? Which one I rather? Ministers don't have nothing to do with it. The procedure manual say how it's done. Chairman of the board must earn his pay and do it properly. Now, Mr. Speaker, Section 35 provides some, shall I say, I better use that word intervention again though, some intrusion by the, and I don't mean that in a derogatory way, by the Minister of Finance when it comes to the capital charges and all that. And I don't disagree with that, Mr. Speaker, but it should be after consultation with the board. And it should be in concert with the enabling legislation for that authority, because you have to talk about what kind of reserves they must have in place and all that other stuff. So I think if we put in that whole section 35, 36, 37, and 38 after consultation with the board, I don't have a problem with it. And I was talking earlier about the personnel management requirements. I believe that this law should require the board of the authority to establish a personnel procedure manual to ensure that all the decisions are made in concert with that manual, and that manual should mirror what's in the public service management law. Because after all, these are government entities. There can be exceptions for some of the regulatory bodies, but that argument should have to be made by the board chairman to the relevant ministry authority as to why he needs to come out of the salary band or salary scale for the chief executive officer of that authority. And all of that, appointments, promotions, remuneration, discipline, dismissal, all of that should be clearly documented in a proper procedure manual approved by the board and consulted with the ministry to make sure that it is in concert with the public management and finance law and the public management service law, the HR section. Because, Madam Speaker, this is why I don't agree with 45. 2. An employee who fails to comply with the Public Service Code of Conduct in a significant way as determined by the Chief Executive Officer may be disciplined or dismissed. By who? But again, it shouldn't be with the Public Service Code of Conduct. It should be with the policy and procedural manual of that authority, which mirrors the Civil Service Code of Conduct. Because I think you want to keep them separate. I don't have a problem now if you want to make the appeals body in the civil service the appeals body for them, because we shouldn't need to reinvent that wheel. But that's a separate and independent entity. But I think when we start crossing up the administrative and managerial functions and roles, I think there's a possibility of some problems down the road. I don't think it's necessary to have 4 to 6. All public authorities shall use the same salary scale as determined by the cabinet, and all jobs shall be evaluated by the same evaluation methodology. Because there are other evaluation methodologies, but again, it should be done in concert with the policy and procedural manual. All that should be in the policy and procedural manual, and it has to be followed, and it should be done every year. So as succession planning and everything else should all be addressed in that manual that is approved by that board for that authority. And as I said earlier, I think they should all fall under the health insurance benefit package, whatever that is for the civil servant, and whether that goes to some kind of co-pay or whatever it is. Whatever exists for central civil service should exist in every one of these authorities. So we don't need, I don't think we need most of 4 to 6. Terms and conditions and remuneration of the staff member a public authority shall take into consideration terms and conditions and remunerations of comparable managerial and technical within the civil service. Should be a given. But it must be in that manual. You shouldn't have to try and figure out what the civil service would do. And on 48, Mr. Speaker, again, the role of cabinet in relation to the public authorities, in my view, the role of cabinet should only be with the board, chairman of the public authority, and not with any other level of the public authorities, because I believe you have the possibility of undermining the board authority, right? And sometimes overinflating the authority of the chief executive officer. Because if cabinet is going to communicate with the public authority, that could well mean with the chief officer. And I think it should only be with the chairman of the board. Same for the duties of cabinet in relation to the public authority, should be public authority board shall be told. I don't have a difficulty with what is delineated here, but I have I want it to be more specific. Same with the duties of the chief officer, again, should be the public authority board. And all communications in this section should be in writing and properly signed off and whatnot, so you know who issued it. Again, we are under miscellaneous 53. We get back into be careful we're not getting back into where we got in with the doctors. What I disagree with in section 49 is that the communication of cabinet is not defined. It is to the authority. I wanted to say to the board chairman of the authority. Because I think you have to also respect the role of the chairman of the board, and not be, cabinet shouldn't be interacting with members of the board but the chairman knowing. But don't suggest which should be done either. I'm saying it's possible. It should be. But as Mr. Scott used to tell us, Governor Scott, I prefer to see the belts and braces around it. Because I know. I was a member, but it wasn't cabinet, it was EXCO. I know that other members of boards that you appoint come to you. Then all I'm saying is that it should be in writing, and it should be, because one of the things we need to maintain if we're talking about governance is the lines of authority and the levels of authority, so that we don't erode the chairman's board if other members are being communicated to, or you're communicating all the way down to the, because that could go down to the chief officer of the authority. That could go down to the janitor. It says the role of cabinet in relation to public authorities is to exercise that the public have duties and functions, owner where relevant for shareholder of public authority, where appropriate, directly intervene in the operation of the public authority. That could be with the janitor. Or I read the whole sentence. Anyway, that's just my view. But I believe that if we're talking about overarching governance, we should do it properly. I don't agree, Mr. Chairman, with 55.4. Under the direction of the chief officer responsible, the internal audit unit and human resources audit unit in the portfolio of the civil service shall regularly monitor the role of the public authority in regard to governance, financial, and personnel management. That's the function of the board. If that necessity arises, then I think it should be done, but it should be done properly in a writing to the board. Well, coming from you, that's 100%. But the amendment I want to see, Mr. Chairman, I know they have an amendment, but I don't agree with their amendment. The chief officer responsible, after consultation with the board, may direct the internal audit unit and human resources unit in the portfolio of civil service to audit the public authority in regard to governance, financial, and personnel management. But I think you should have to consult with the board. Because there should be a documentable reason why you want these people to intervene. Mr. Speaker, if we can sit down and negotiate some of these improvements to the legislation, I will be able to support the bill. Thank you, Mr. Speaker.
Does any other member wish to speak? Call on the Honorable Premier.
Thank you, Mr. Speaker. Mr. Speaker, this is such an important bill and has been so long in coming that although others on this side who have spoken or will speak are more than capable of articulating what the objectives of the bill are and the way that it will operate, I thought that I would just offer a few words on my part as to how important I think this bill actually is. Mr. Speaker, the development and use of public authorities in these islands is, as in our overall, in the overall context of government in Cayman, is still relatively new. And the purpose of it, as best as I can discern, was that it was felt that with respect to certain specific areas of the government activity, it was more suitable to have a more private sector management approach to these areas. And in some instances, it was an effort to be able to obtain the kind of specialist staff that was necessary with respect to some of these areas of government endeavor, because a lot of the specialist posts attract significantly higher salaries and benefit packages than does the general civil service employment arrangement and salary scales. I think that was probably sensible in some respects. I do, like the leader of the opposition, share some concern that perhaps we have created over time, I don't mean this particular administration, we have created some statutory authorities that are unnecessary, and that there are some areas which would probably better and more efficiently be managed within the civil service regime. So, Mr. Speaker, I think one of the consequences of the way we've gone about this over time is that it was felt that it was necessary to give these authorities a great deal of autonomy, if not complete autonomy. And that in some instances has been pushed to the absolute limit, where it appears in some instances that authorities feel that they are accountable to no one. And that it is, some of them, I've had this personal experience with on some occasions, where you can actually see them bristle when you suggest that as a minister or as a member of the cabinet that there is something not right, or in your view, about the way they've gone about certain things, whether it's hiring or whether it's with respect to certain policy, whether it's with respect to fees. And we've had some really good or bad, depending how you look at it, examples of when these things go bad. I know, Mr. Speaker, you have expressed concern about this for as long as I can remember. Certainly in the 4 years that I served in cabinet with you, from 2005 to 2009, you were always pointing to the problems and the dangers and the issues with, in some cases, not all cases, sort of runaway authorities who seem to operate on the basis that they had no level of accountability to government, whether it was with respect to them contributing to government coffers or with respect to policy. I think that, and I know there's been a great deal of pushback about a public authorities bill. We tried it to get it won through in the 2005 to 2009 administration. In the end, we were defeated by the sheer number of protests about it. But as time has gone on, Mr. Speaker, I think it's become more and more apparent that the clear message has to be sent and understood that no authority, no statutory company, no department of government, no ministry is an island unto itself, and that they all have to function as part of the overall government apparatus, and they all have to reflect in what they do the policies of the administration that the people have elected. We who are elected are accountable. No one and no entity can expect to be without accountability. If there are not those checks and balances, then that's when we get into some really, really bad situations. And we have some real Cayman examples that we can now point to. The thing with the public authorities and statutory companies is that they don't all perform the same kind of functions. Some are regulatory bodies, others have a more operational type of character, and some have a mixture of both. And so the challenge really in developing legislation like this, which will give the government, the elected government, the ability to help direct policy, to ensure that its authorities and statutory-owned companies are doing its will in terms of carrying out the mandate which the government has, is balancing that with the absolute need for operational independence and non-interference with respect to regulatory functions of these various entities. And that's what this legislation, Mr. Speaker, seeks to achieve. I think, Mr. Speaker, that it goes a long way to doing that. It is not perfect. We don't believe it is. There are already, as we've indicated, some significant number of proposed amendments on this end. I repeat, this is not unusual. Most bills of any size that have come to the House, certainly in the 16 plus years I've been here, are always the subject of committee stage amendments. Amendments by the government and amendments proposed by the opposition. That's a clear indication that the system is working. That's what the committee stage is about, the detailed analysis and consideration of each clause of the bill with a view to getting it as right as possible. And again, I heard a member saying with respect to another bill earlier today, they want it in the law because they want it set in stone. The number of amendments that that occur to laws in this House on a regular basis should be a clear indication to everyone that there is no such thing as legislation set in stone. That's the whole reason we are here as legislators, to reflect the changes in views and policies and to correct errors as a legislature. Mr. Speaker, I wish to address a few points that were raised by a couple of the members on the other side, the Leader of the Opposition in particular, and the member from North Side. With respect to the allegations by the Leader of the Opposition, although he did qualify them by saying this is what he was told, that there was not adequate consultation with respect to this bill, I would just, Mr. Speaker, wish to outline the series of meetings and discussions which occurred. The first consultation, Mr. Speaker, was with the Audit Office with respect to the initial draft of the bill that was put up. And remember, Mr. Speaker, this has been knocking around from about 2006, 2007, so we weren't starting from scratch. Caucus considered that draft bill carefully on the 25th of August 2014. There were proposals made by the caucus, and the bill was altered. There was another caucus session on the 1st of September 2014, again for the changes. Another caucus session on the 3rd of November 2014, and again further changes were made. Then, Mr. Speaker, all chairmen and deputy chairmen of all of the government-owned companies and statutory authorities were invited to presentations in February of 2015. Some 29 persons attended that. There were meetings with Cayman National Cultural Foundation, the Maritime Authority, National Housing Development Trust, and the Sister Islands Affordable Housing Corporation were the only entities that were not represented. 11 of the public authorities responded in writing, and some comments were included in the revised draft. Chief officers were consulted. minor changes were made to that draft, and the bill was approved by the cabinet in December of last year. The deputy governor met with the Cayman Islands Mountain Authority Board in December 2016, and the other point I wish to make is 2 chief executive officers were part of the project team that prepared the bill. So the statutory authorities and government-owned companies nominated 2 of their chief executive officers to participate in the drafting of the bill. And in addition, Mr. Speaker, there were numerous email exchanges back and forth about various aspects of the bill with the statutory authorities and government-owned companies. I am satisfied, more than satisfied, Mr. Speaker, that this bill is the subject or is the result of extensive consultation. Does that mean that every single person or every entity agrees with what is in the bill and everything's in the bill? Absolutely not. But I think if we wait around until we get unanimous approval on every clause in the bill, it'll take more than the 8 plus, how many years? 12 plus years that it's taken to get here. Mr. Speaker, I just want to address a number of other concerns that were raised by my friend, the member from Northside. Mr. Speaker, I understand how attractive the proposition is that everything that the statutory authorities, government-owned companies are required to do or to comply with in terms of salaries, salary scales, gradings, benefits, that they all mirror what is the case with the civil service. But, Mr. Speaker, that is simply not possible. In fact, as I said at the start of my contribution, one of the key reasons why statutory authorities were developed was to take the salaries and benefit issues outside the scope of what the civil service rules require. And that is because, Mr. Speaker, there are a significant number of specialist positions which could not be accommodated without a great deal of violence being done to the overall system itself, could not be accommodated within the salary scales that are set up for the civil service. And at the end of the day, the market pays what the market pays, and for a particular type of skill and experience. And if you are not able to offer what the market pays, you are not going to get the kind of specialist that you need. Now, that is a reality. It was a reality when the idea of public authorities was first initiated in Cayman, and it's the reality now. The problem which I know the member is concerned about is that without some level of external control on issues like salaries, we have seen some public authorities go, we believe, way beyond what is reasonable in terms of remuneration packages. And so the proposal that the cabinet has a role in agreeing these overall salary levels is an attempt to strike that balance between allowing the authority to do what it needs to do in terms of offers to get the quality and specialist staff it needs in appropriate circumstances, while the cabinet has the overall ability to say, this is reasonable or this is not. And that is why we have introduced these new provisions, which are currently not the case. At the moment, the authorities do what they wish with respect to deciding what salaries they're going to pay for the various positions. Mr. Speaker, I do agree with the view of the member from Northside, though, about health insurance coverage. There is absolutely no reason, in fact, the converse is true. There is every good reason why all public servants should fall under the remit for coverage of Cineco. It is not to their advantage, despite what some may think. It seems that they think the advantage is that they have their choice of private sector doctors in Cayman. But if there is a more generous health insurance coverage package in the world than Cineco provides to civil servants and those that are covered by it, then somebody need to tell me about it. Because there is no limit to the overall financial benefit for your entire lifetime. And as I've had the same experience that the member from Northside has had, where I've had former or about to become retired public servants who are leaving a statutory authority and who, in those two instances that I speak about, had chronic ailments. What will happen to me now, because the coverage from the private sector health provider that they had for as long as they've been there will fall away in a few months after they've left. So I think that is one area that we need to continue to explore, because I don't think that it is either in the interest of the people who work with the statutory authorities or the overall interest of government that they are outside the scope of Cineco. Mr. Speaker, with respect to the responsibilities of cabinet in relation to, and chief officers in relation to public authorities, for the sake of clarity, because I do believe that what the member from Northside said may have cast some doubt on this, I wish to read, with your permission, sir, clauses 48 and 49 of the bill. Clause 48, the role of the cabinet in relation to public authorities is to A, exercise on the public's behalf the duties and functions of the owner or, where relevant, shareholder of the public authority. B, where appropriate, directly intervene in the operation of the public authority where it is in the public interest to do so, by giving general and lawful directions in written form as to the policy to be followed by the public authority in the performance of its duties and functions. Mr. Speaker, I'll pause there to offer a few observations. The role of the cabinet, acting on behalf of the government of the Cayman Islands, and therefore the people of the Cayman Islands, is the sole shareholder of all of these government companies and statutory authorities. And the cabinet is the chief executive authority in these islands, save for the areas reserved for Her Excellency under Section 55 of the Constitution, referred to as the special responsibilities. So it is not only perfectly lawful, but perfectly logical for the cabinet to exercise the responsibilities of any owner, any shareholder of any of these authorities. Secondly, it is appropriate for the shareholder to intervene when it believes it is in the public interest to do so, to ensure that the public authority or statutory owned company is carrying out policies which are consistent with the mandate that the government has. These authorities are not out on their own, as some of them seem to believe, doing their own thing. Okay. Mr. Chairman, Mr. Speaker, I have converted the member from Northside. Mr. Speaker, Clause 48C. The role of the Cabinet is to order an investigation pursuant to Section 55(2) into the public authority's compliance with this law. In other words, where it appears to the Cabinet that a public authority is not acting in accordance with the law, this law, it can order an investigation to ensure that, or to find out whether or not the statutory authority, public-owned statutory company or public authority is doing what it ought to be doing in terms of carrying out policies, implementing policies which are consistent with the mandate of the government. And D, extend policy that applies to the civil service to the public authorities as and when necessary to ensure good governance and best human resource practice. So let us use a fairly recent example of where that would apply. So government is in a crisis situation financially, and there's a cash crunch, and the deputy governor, on behalf of the elected government, orders that there is a freeze in the hiring of civil servants, public servants, and orders a cap or a reduction in salaries. When that occurred in the recent past, there were some statutory authorities that said, that doesn't apply to us. And while civil servants were taking a cut in salary, public servants working for certain statutory authorities were receiving raises and bonuses. And hiring as they saw fit. So this provision will allow the government, the cabinet, to say, you must comply with these particular policies which have been extended to the civil service, which are now being applied to the civil service, they are being extended to you. We still on the same page? Good. 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 The duties, Clause 49, the duties of the Cabinet in relation to a public authority shall be A, to appoint board members in accordance with the provisions of Part 3, B, agree the ownership performance required of the public authority with the board of the public authority, and to monitor the achievement of that performance in accordance with the provisions of the Public Management and Finance Law, 2013 revision. That, Mr. Speaker, I think is eminently sensible, so that there is no question on the part of the board what it is that the government wishes to see done. In the same way that the government enters into, each minister enters into perform an ownership performance agreement with his or her chief officer. This is what the government wishes to get done over this period. The same thing is done with respect to the statutory authorities and government-owned companies, and the performance of that is measured. Good. You should have said that when you got up. Then I wouldn't have to go through all of this. No, I'm not at all. I thank you. I thank you, Member for Northside, for having clarified your position. But I need to make sure that the entire public was not misled, I'm sure unintentionally by you in your contribution that you made. So I have to make sure that the government's message is out there. The duties of the cabinet in relation to the public authority shall be to where relevant, agree the outputs to be delivered by the public authority and funded by the cabinet with the board, and monitor the delivery of those outputs in accordance with the provisions of the public management and finance law. I just went through that. D, determine a public authority's purpose in the relevant legislation and review such purpose as and when necessary. Again, Mr. Speaker, reinforcing the point that authorities do not exist for the sake of existing, that they are there as instruments of the government and to pursue and effect the mandate of the government. And finally, Mr. Speaker, to give the chief officer of the relevant ministry oversight of the public authority and power to act as liaison officer for the board, the chief executive officer, and responsible minister or official member. And so, Mr. Speaker, I hope that is able to set out in broad and hopefully understandable terms what the purpose of this legislation is. It is to bring the public authorities and government-owned companies within the overall framework of the public service so that there is not only accountability to the cabinet, but there is active involvement of the cabinet and each individual ministry that has a role in the area of endeavor of that particular authority, so that what is done by the public authorities and government-owned companies is consistent with the government's overall plan of action and objectives. And it will also give the cabinet some control over the levels of expenditure and create a system of accountability on the part of the public authorities and government-owned companies, so that a new culture develops where they see themselves as part of the overall framework of government, helping the government to achieve its objectives, and where possible, contributing to government revenue and providing the various services that they were established to do in the first place. I thank you, Mr. Speaker.
Does any other member wish to speak? Does any honorable fifth elected member from Georgetown?
Thank you, Mr. Speaker. Mr. Speaker, I rise to add my contribution to the debate. And having listened to a number of the speakers before, I have some concerns. Mr. Speaker, I'm glad to see some of the proposed committee stage amendments, because they have addressed some of the issues that I originally had when researching and putting together my contribution. Mr. Speaker, one thing in particular that I find, and I'll mention it up front before I go into further detail, is the one right at the end, clause 59 of the bill. Says, in the event of any inconsistency between this law and the operation of any other law, this law shall prevail to the extent of the inconsistency. Mr. Speaker, maybe it's because of my professional past, but when you look at entities like the Monetary Authority that are already subject to Monetary Authority law, and noting its international obligations, its ability or its need to have its independence under the IMF, the FATF, its requirements to hire the best staff, which under the FATF and IMF set out specific skill sets and qualifications. Noting in the past where it's been very difficult to hire persons for specific roles. And I'm thinking most recently about the head of insurance. All these things, Mr. Speaker, we have to be careful about. Because if this law overrides that law, then we have problems internationally, and this could turn into a Pandora's box. And I raised SEMA, and I think there are a few others in there, and I think somebody else has raised it, maybe the Civil Aviation Authority and other ones that have the ship registry, I heard other people say, that have these things. And so we have to be very careful about what their international obligations are, just because of what their function is and how their setup is, that this law does not cancel out or override that. Because when they have these international audits and assessments, that could come up and be an issue. I think, Mr. Speaker, and it sounded like someone else said it before, that carving out a SEMA and a CIA and possibly some others that have these bespoke and specific obligations should be something that we look to, including possibly amending their existing legislation to cover some of these issues so it's complementary rather than superseding, right? We can achieve some of the same things we say we want to achieve by amending theirs and keeping them separate, because I'm sure SEMA isn't the same as a Tourism Attractions Board, right? So when we say we're going to put these in concert, we have to understand and recognize the nuances. And again, particularly talking about SEMA as a globally recognized regulator, it's absolutely imperative and important that it remains independent. But at the same time, because of this specialized skill sets, there are going to be rules in SEMA and some of the other ones that were mentioned before, that if you want to hire the best available, you're going to have to pay market price. And sometimes I would contend that market price is not going to fall within that box or anywhere near it. So when the Premier says that Cabinet will look at these things, it has to look at them not in light of, well, you know, these are high salaries for somebody that's working in a statutory authority that's run by government, but in light of some of those international benchmarks that would make some of those salaries a lot higher than maybe some of us would like them to be or care for them to be. But if we're going to be competitive, then they have to be. If not, we're going to have real struggles, Mr. Speaker, to recruit experienced people that have the ability to ply their wares with our competitors. And that's not good for anybody. Mr. Speaker, you look at the liability section under Clause 53, and it talks about the liability of employees going forward. And this, I think, covers board and staff, unless somebody will correct me otherwise. Mr. Speaker, negligence and bad faith. I don't know where these hurdles came in, or after, you know, what consultation that standard was set. But I fear that if board and staff feel that they can be sued for negligence, you might not have a lot of people taking up the role. You know, when you look at governance indemnity clauses in other professions in the private sector, sometimes you see the words, the standard being a willful default or fraud, right? Which those are standards that are that take a lot of proactive behavior, meaning you can't stumble across those types of hurdles. You have to actively jump them, and that gives the person carrying out the fiduciary role a bit more comfort that they're not going to inadvertently or otherwise stumble across and be sued in these instances. So again, I don't know what the process was and what those standards, where those standards originated, but I would suggest that if you look at the private sector and you look at perhaps getting some examples of those, you really want to zero in on them, or you might affect the type of person wanting to come and serve on that board because they'd be concerned about those indemnity clauses. And under this, as a director in my old role, where this is what I did for a living, especially in this type of scenario with some of these clauses, I would second guess, being appointed to one of these boards. But I just give it as I get it, and it's one of those things where you might want to look at that again with someone in the private sector. When we hear, some of the reasons for this bill, Mr. Speaker, the common salary scale, the preference to Cayman employment, the accountability. We just need to look, I think, realistically as well as to what we're trying to do, because one size does not fit all in the statutory authorities. That should be our starting point. So to try to get them all on the same page, that is a Herculean task, Mr. Speaker. I absolutely agree with the Deputy Governor that we want consistency and we want to make the operations better. We want to enhance their effectiveness, and there should be broad public policy goals. Mr. Speaker, these are things that we should all be striving for. But again, with the caveat that we can't use a hammer for a peanut. If some of these functions don't line up, if we say, and I think this actually came from this side, so I'm going to say it, and I don't agree with it, but actually it'll show our independence, on this side as well. Some people think we're some sort of party. But if we look at having these meetings public, and the minutes public and not redacted, I think we could end up in some serious issues, especially with some of these boards that do, or these authorities that do the regulatory issues. So again, it's not a one size fits all. I would go to and say a majority of them could possibly have public meetings and minutes that are out there, but there are absolutely a few of them that you should never sit down in a public arena and show that decision role, what they're looking and what their goals and aims are, because sometimes that could be tipping off, right? So, Speaker, we do have to be careful. Mr. Speaker, I've heard, and I've heard the Premier and the Deputy Governor say that there was wide consultation. But again, I guess because we're the opposition and because people come to us and give us things in order to raise during these types of processes, I was told, and again, I only say it because it's actually been addressed, but I don't think this particular issue was addressed, and I stand to be corrected if I'm wrong. I can only go on what I've been told that the committee didn't actually meet in this process. And, if that's the case, then I think that was an issue, right? Mr. Speaker, I think that, and I hope that each SAGC was reviewed in its own skin, in its own space, before these kind of general sweeping changes were made, because those differences were identified and zeroed in on, especially the ones like SEMA and other things, because when when you're reviewing salaries and dividend structures and all those things, you have to kind of look at them in context. It just can't be SAGC's one size fits all. I'm not here to talk a lot about things like medical and that sort of stuff. I've long been an advocate of you pay, you get a choice, and you know, you go from there. I understand cynical, I understand the reasons why both the Premier and the member from Northside spoke about that pooling, right, effect. But again, whatever the discussion, because we've heard, you know, now that government was talking about co-pay and other things like that as well. I do agree that there needs to be some sort of standard approach, whatever it is, and that you need to look at the overall cost-benefit analysis and to see how the SAGCs and the core government on one hand, you know, what's the best solution. But I just raised that because there have been discussions of late of changing the kind of co-pay structure, et cetera. We also, Mr. Speaker, need to look at some of these changes, again, in the economic context. Can we achieve all the things that we want to achieve, set up all the systems that we want to set up in an affordable and efficient way? Because it's good to say it. It's good to stand on principle, but at some point in time, you got to pay the piper as well. So I'm sure, and I hope, that analysis has been done, but that overall cost to, I'm just use this word colloquially, reining in the SAGCs, there's a cost to doing that needed and needs to, if it has not been done, to be contemplated and quantified. Just one more point on pensions and insurance, though. Again, talking about something like SEMA, who's responsible for regulating some of those. You've got to be a bit careful if they're caught up in the same usage of the entities that they're regulating. And I leave that for more learned people than I am in the public policy and management. Like the member from Northside, I have some issues with the 40% of the board being civil servants. And those issues surround, again, the separation of functions, the reason why you have a competent board in the first place, and also the line of communication and accountability up the ladder. And we've heard in here that, you know, sometimes you worry about influence. You also worry about possible conflicts, Madam Speaker, Mr. Speaker. I think that 40% should be lower. I think that representatives of the ministry should be there, but it shouldn't be almost as we're inserting Big Brother into the equation, and Big Brother is going to be watching you so that you always have this kind of conscience on your shoulder. Mr. Speaker, the contributions from the SAGCs and the dividend paid to the government I think, again, we have to look at the individual SAGCs, their functions, their track record, their ability to capture revenue and be able to pay back those dividends. So I just look at it and say, we have to just be very careful, Mr. Speaker, when we're kind of putting these all in one basket, because one size doesn't fit all. Mr. Speaker, maybe in his wind up, the Deputy Governor can talk about those remuneration packages and why, in some instances, market rate would dictate bonuses and other things, if that's what competent SAGCs across the region or internationally that we compete with, right? The main areas that we compete with, what those packages are, and then, you know, use that as the gray area when cabinet, or you know, not a gray area, but add that to the equation when cabinet's making the decision, because it is not just black and white. It's not just, you know, so. Mr. Speaker, I think some of the other members who spoke also raised the issue of what the Auditor General, well, two Auditor Generals have said about the Public Authorities Bill. And I'm sure that the Deputy Governor has gone through these comments, but what I want to do is raise them so that he can answer them in his response, to say whether that these have been covered off, more so for the listening audience and those interested in this bill. In 2014, the then Auditor General talked about the fact that the legislation was trying to improve management of public authorities. The office spoke about sometimes going into too much detail where the roles and functions would be too prescribed, that the guidance in that legislation may, in fact, have unintended impact on the role of these boards and would actually preclude good practice. And Mr. Speaker, I'll tell the Deputy Governor where I'm getting that from, so if he wants to look at it, and I'm happy to table this document afterwards or get copies for people. This was on page 2 under the purpose of the proposed legislation and the penultimate paragraph, Mr. Speaker. The Auditor General went on to say that under duties and responsibilities, paragraph 3, on page 3, in a number of places in the proposed legislation, there is an attempt to list all the duties and responsibilities of certain positions in the governance framework. We believe that this practice may not be appropriate, as it is not possible at times to define all the duties and responsibilities in detail, but rather to describe the role and responsibility in broad terms. With so much detail, the individuals will do exactly what is stated and not necessarily the way it was intended. We therefore recommend that the proposed legislation move to more broad descriptions of the nature of the roles and responsibilities and leave the detail for administrative guidance. And Mr. Speaker, I raise that because what I want to say to this Honorable House and those listening is that sometimes with the best intentions, after hiring what we would consider a competent board based on skill sets and experience and all those things, if we then try to constrain them too much, then that board isn't actually carrying out the function that we wanted them to do. I use their collective skill sets, their experiences to guide us versus us prescribing all their actions. So again, it's one of those things where the law of unintended consequences, when you try to fetter that board, could come back to haunt us. The other thing that the Auditor General said at the time was that when they pointed out the PMFL and PSML, that they would need to be strengthened and consistent with these changes. So again, that's the cost factor that I was talking about, some of those things that you need to consider when you're putting these things in place. And they go on to say on page 4, under impact on current SAGC legislation, says the governance audit found that neither the provisions in these two laws, i.e. the PMFL and PSML, were fully implemented, nor the provisions that were implemented worked effectively. So we need to look at all the laws in all the SAGCs and governing them, and to ensure that there are no inconsistencies, overrides, any of these unintended consequences for putting this in place. And that will be, I guess, in conjunction with the Auditor General. The Auditor General, but also with the Attorney General to look at some of these laws. And on page 5, Mr. Speaker, the Auditor General went on, and in the third paragraph of page 5, said, for this reason we believe that it is for this reason we believe that the new legislation should be, as much as possible, complementary to the existing legislation to provide the framework for strengthening what is already there. Speaker, on page 6, the Auditor General went on under ethics and values, which is also paragraph 6 our audit of governance in the public authorities found considerable issues with values and ethics, a key element of good governance. And I'm skipping here, Mr. Speaker, but I'm still using that same paragraph. It's a short paragraph. I'm skipping to the last sentence. And that is to say that no matter how detailed and how specific legislation is drafted for the good governance of public authorities, it will not work unless a greater amount of effort is spent to address the core issue of values and ethics. Speaker, when we're looking at these SAGCs, we also need, I think, to look at the potential conflicts, etc., in all the public appointed boards. Because some of these things that we claim that we want to rein in the SAGCs about, some of the things about conflicts and other things, we know it exists already in other boards. And if we're using an exercise like this, and we're using these reasons for it, we need to critically look at all the instances where we have perceived or actual conflicts on some of these boards and get it right all at the same time. Because you can't rein in something and bring them into what you consider core government values and everything else when that needs fixing itself. So we need to look carefully and critically at these things. And I just touch on page 7 where they talk about audit committees and that authorities should be required to establish audit committees. And I for one, Mr. Speaker, think that's probably one of the most important committees that any of these boards could have. And it's something that goes along with good governance, and if not, we should really look at putting those in place. And I don't know, I can't remember if it's in the committee stage or otherwise, but I didn't see it in the actual bill that I read. But let's put it out there.
Honorable member, you said you wanted to table those
Yes,
things from
sorry.
Dr. Gerald. So ordered.
Yeah, thank you, Mr. Speaker. I will say that has my highlighted bits in there, but that was only for my own edification. Yeah. Mr. Speaker, I just spoke about the conflicts issue, and I trust that definition based on the current topic or in the LA, the definition will be forthcoming from the Deputy Governor and the Attorney General at some point in time, because these conflicts, especially in these pertinent and very important boards, I think people need more education, especially the board members that are being appointed. They need to go through some of these exercises. One would assume that, but I think that part of good governance is to have the proper and comprehensive training for these boards covering all the pertinent issues. And if conflicts are being used as a key reason for change, then it's time to look at the proper training of those board members. I spoke about the heaviness of government. I spoke about the salaries. Speaker, I won't dwell on those. But I'll move on and say I was happy that the whistleblower protection law 2016 was incorporated in here, because again, that's an important accountability law, and by reference it highlights the intent of the drafters under clause 56. We just have to remember, Mr. Speaker, that sometimes the weight of government on a statutory authority and board can serve to make it more sluggish, and that for the authorities that need to be nimble and to make adjustments to meet immediate demands, that we could be slowing them down and putting in bureaucratic hurdles for them. So I would ask for that to be considered. For the ones that need to be as nimble as possible, that we have a lighter hand at for some of them, because they need to react to markets and not kind of have the top-down approach. And that will allow them to be more efficient and capable to meeting and adapting to those needs. I've stressed the SEMA point that they have to be as autonomous as possible to a large degree. And I would only end with, when I was doing my research, Mr. Speaker, when you look at, again, a competitor of ours in Bermuda, they recently, I think last year, went through an exercise where they did the carve-out, Mr. Speaker, and they particularly looked at the shipping and maritime authority and the civil aviation authority, and they enhanced their separate legislation and kept them kind of outside of that scope, because again they cited that those two in particular needed to be, and I'm quoting, efficient, competitive, and economically viable, that can meet modern day customer demands as well as national and international standards. And I would try to impress upon the Deputy Governor and his team that those things, those reasons need to be looked at, and again, maybe some tweaks that need to be made could be made if those are found pertinent enough to do so. And we have to remember that our competitors are also watching us, whereas they have followed us in the past. What we don't want to do is flip the coin where we're following them in some of these instances. And we need to retain that competitive edge in areas like the global aviation market and global maritime market, and and involving the Monetary Authority for all the reasons I've stated in my contribution, Mr. Speaker. Sometimes, if government becomes too involved, it's not necessarily a good thing. I understand that there needs to be some uniformity, but we just have to tread carefully and try to avoid that thing called the law of unintended consequences. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? If not, does the mover wish to exercise his right to respond?
Mr. Speaker, thank you. And I would like to thank all members for their contributions, and I can respond to some of the points that were raised. Mr. Speaker, Premier, in his debate, did address this issue, but I just want to say it again in relation to there being no consultation. Mr. Speaker, in my 5 years as Deputy Governor and dealing with various bills, I can't remember a time where there has been more consultation than with this bill. We have had numerous meetings, numerous email correspondence. I have personally met with the SEMA board to hear specifically what their concerns were. As the member, as the fifth elected member for Georgetown said, and the leader of the opposition said, SEMA is a very important regulator, probably our supreme regulator, and we want to make sure that we were not doing anything that would compromise their independence. The Minister for Financial Services, doing our consultation with him, made it very clear that all efforts must be made to ensure that anything that we did not impinge on SEMA's and the rest of the regulatory SIGC's independence. And we believe we have achieved that by the various amendments that we have put in place at the committee stage. Mr. Speaker, and also the fifth elected member for Georgetown did mention that he was advised that the committee that were looking at this didn't actually meet. Well, we have recorded 60 hours of meetings for that committee. I sat in on some of the meetings. I didn't sit in on all of them. That's why I had the committee. But they did meet. The member from East End tabled the report from the Auditor General. That information...
Mr. Speaker, I don't
Member
recall,
from East End.
thank you for allowing me this intervention. I don't recall tabling anything here.
My mistake. I meant fifth elected member for Georgetown. My apologies.
Yeah.
My apologies.
Understood.
Yes.
Deputy Governor.
Yeah. My apologies, Mr. Speaker. Let me start over. The document that was tabled by the fifth elected member from Georgetown, from the Auditor General, who was an advisor to the committee, shows that the committee was meeting. He attended the meeting, we gave him a presentation on the bill, and he gave us back the feedback. Just to finalize that point, the Auditor General made a comment that he believed that some of the provisions in the bill were a bit too specific. We really didn't agree with that. We wanted to actually spell out in detail what the responsibilities of the board were so that there was no misconception. So we didn't agree with him on that point, and we certainly didn't see anything wrong with us putting in detail some of the responsibilities. The leader of the opposition said that he believed that maybe it's timely that we review all of the SAGCs and see which ones should be brought back into government. I think that's a good idea. It's time for that. But certainly after we get through this bill, then we can look at other things in relation to that. It was mentioned that not all the civil service policies and procedures will be good for the SAGCs, and we agree with that. But the bill does give the cabinet the authority to require the SAGCs to implement those policies which the cabinet believes will make them more efficient and more effective. Not everyone will work with that. The member from Northside made some very good points. Some of his committee stage amendments we agree with. So I'm not going to go into too many details in relation to what he said. We differ in what he said that civil servants shouldn't sit on boards. I want to make it very clear that we are not mandating how many civil servants will sit on the board. The bill says no more than 40% of the board members should be civil servants. No more than 40%. It could be 10%, but it shouldn't be more than 40%. So we believe that will address some of the concerns. Okay, so that bill now will come into line with with this bill. That is why it's important that the clause that says if there's any conflict with the laws, that the public authorities bill should take precedent for that exact same reason. Mr. Speaker, the member from Northside talked about all of the board meetings should be public. We don't necessarily agree with that. We couldn't require, for example, some of our regulatory authorities to have their board meetings in public, SEMA, Civil Aviation Authority, our shipping, our maritime authority, for commercial reasons, commercial sensitivity, some of the things that they are discussing. But we have a FOI law that does allow for minutes and things to be published, so we think that will address some of the concerns that were raised. There was a question about the liability provisions. And Mr. Speaker, it was said very clearly, this was one of the concerns from SEMA, is that if we don't give these type of protections to their board members, they just will not be able to attract the right caliber board members. So we have to give them some protection. They're not that well paid. Mr. Speaker, there was a lot of talk about in relation to salaries and the authority's ability to attract best talent. That was something that came out very strongly in the consultations that we had, and we are bringing a committee stage amendment that will deal with that without going into too much detail. Basically what it says is that if the authority is having difficulty attracting someone for a specific position because of salary, and it doesn't fit within the new salary scale, they will be allowed to inflate that salary based on market availability. So they will be able to go outside of the salary scale. Of course, that will have to be done in consultation so that it's a very open and transparent process. And that would apply to the CEO as well. The board, if they can't find the right person to be their CEO because of salary, they can go outside of the salary scale. So, Mr. Speaker, we took this bill very, very seriously. As the Premier said, it's a very, very important piece of legislation. That is why our consultation was broad. It was for a very long period of time. We had 60 hours of committee meetings where we went through this in detail to make sure that we were addressing the concerns. The member who spoke from Georgetown, the fifth elected member, said, the laws of unintended consequences. We wanted to make sure that we looked into that as well. And we believe, Mr. Speaker, that with the committee stage amendments that we've put in place, it will address the majority of concerns that have been raised here by members. And at the end of that period, we will be able to have broad support for the bill. So with those few words, Mr. Speaker, I thank everyone for their support of the bill. Thank you.
The question is that a bill shortly entitled the Public Authorities Bill 2016 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Public Authorities Bill 2016 has been given a second reading.
the Police Complaints by the Public Bill 2016.
I call on Honorable Deputy Governor.
Mr. Speaker, I beg to move a bill shortly entitled the Police Complaints from the Public Bill 2016.
The bill has been duly moved. Does the mover wish to speak thereto?
Yes, Madam. Yes, Mr. Speaker. Thank you very much. Mr. Speaker, I rise to introduce the Police Complaints from the Public Bill 2016. Mr. Speaker, the existing police law was enacted in 2010. Part 7 and Schedule 4 of that law provided for the establishment of a police public complaints authority as a statutory authority. Although the police law was enacted, the authority was not set up, which means that for the past 6 years, there has been no independent mechanism for dealing with public complaints against the police for the last 6 years, Mr. Speaker. So this is timely. After due consideration of the way forward, the government decided that in a small jurisdiction like the Cayman Islands, it was not economically feasible to set up another oversight agency with independent administration and investigators. Based on the anticipated workload, the cost could just not be justified. It was estimated that an average of 100 routine complaints were made against the police per annum, of which 10 could be considered serious. Let me say that again. It was estimated that an average of 100 routine complaints were made against the police per annum, of which 10 could be considered serious. Furthermore, the cost to set up a statutory authority to deal with complaints against the police would cost between $750,000 to $1 million per annum. Mr. Speaker, the question that should be answered from the onset is, why do we need an independent entity to deal with complaints against the police? There has been a long-standing international debate between supporters of internal police review and advocates of independent review. While the police may argue that internal review would be swifter and more effective, those advocating for independent review argue that it is essential in a democracy, since police are ultimately responsible to the public and not just to their police chief. The civilian review argument has been accepted in many countries around the world for many very persuasive reasons. For example, it has been argued that it establishes the principle of police accountability. It is an important source of information about police misconduct. It alerts police forces to the steps they should take to curb abuse and discourage misconduct amongst police officers. The implementation of independent review can help to ensure that reforms are implemented and leads to improvements in police policies and procedures. Improves the image of the police and its relationship with the public, as complaints are dealt with in an independent and transparent way. Mr. Speaker, the unmistakable international trend in police complaints reform has been towards greater independence and the transfer of responsibilities from police forces to independent bodies with investigative powers. The reform trend has not been global, sir. It has mainly been in English-speaking jurisdictions in North America, Canada, the UK, Ireland, Australia, and New Zealand. This trend has been slow to spread to states in Asia, Africa, and South America. Mr. Speaker, in research carried out prior to developing this bill, My staff looked at the Independent Police Conduct Authority in New Zealand, the Commission for Police Complaints Against the Royal Cayman Islands, the Royal Canadian Mounted Police, the Police Complaints Authority in Bermuda, and the Jamaican Independent Commission of Investigation. In fact, Mr. Speaker, I met with the Independent Police Complaints Commission on one of my visits to the UK a few years ago. The visit was very informative, and I met with the chief executive and one of their commissioners to understand how exactly that office operates and what lessons we could learn from them. Mr. Speaker, the EY report recommended that public complaints against the police could be dealt with by a new office of the Ombudsman. The government agreed with this recommendation and included it as part of Project Future. The outline business case was approved by Cabinet in March 2016 and a project team established. The project team recommended that legislation was required for public complaints against the police to be dealt with by an oversight body. The principles require such an oversight body to be independent of the executive, have independent investigative resources, have adequate powers, have parliamentary oversight, and of course have sufficient resources and funding. Mr. Speaker, I'm very pleased to say that all of these principles have been met in this new bill. Mr. Speaker, let me explain further what is meant by parliamentary oversight. The Ombudsman will be independent. This is set out in Clause 120 of the Constitution. This means that the Ombudsman must not be bound by any external instruction other than by the Ombudsman law. Parliament will not have the authority to instruct him or influence him in the recommendation he or she makes with regard to the police complaints, maladministration complaints, or freedom of information appeals. However, the Ombudsman will have to account to Parliament for his budget and expenditure and will be responsible to present an annual report of his activities, which will then be tabled here and made public, which means that the operations of these offices will be public. Police complaints, for the very first time, will be made public. What kind of how many complaints there were, how were they resolved, it will shine a light on this very, very important area, Mr. Speaker. Mr. Speaker, this is no different than what exists at the moment in relation to the Office of the Complaints Commissioner, which deal with complaints against other uniformed services. That is a parliamentary body. So there's nothing different from what actually happens today. Parliamentary oversight of entities dealing with police complaints is common. It happens in the UK and in Canada. Mr. Speaker, the police complaints from the public bill will make provisions for the Office of the Ombudsman to investigate public complaints against the police. The new Office of the Ombudsman will recruit a Deputy Ombudsman complaints who will be directly responsible for specialist police investigators. There are a number of implementation steps that need to be undertaken before it's operational. Firstly, we will have to recruit qualified and experienced staff. We will have to develop new policies and procedures manuals and a complaint system for the office. We will then need to be on a campaign to educate the public because, Mr. Speaker, this is going to be critical. Our public education on this matter has to be exceptional so that everyone is clear, including police officers, how this new system will operate. The Office of the Ombudsman will have to agree MOUs with international agencies that we may need to call in for investigative resources. So, Mr. Speaker, if, for example, the very unfortunate police shooting that we had a few months ago, if that had happened when this bill comes into force, what would normally happen is that that office would have had an arrangement with a force outside of the Cayman Islands, that they would call and immediately get people to come in and investigate that police shooting so that it was open and transparent, complete their investigation, and then make a report to the DPP. The new bill defines police as any member of the RCIPS and includes a recruit constable, a probationary constable, an auxiliary constable, and a community support officer. It includes persons who has resigned but was obviously subject to a complaint, and includes any other public servant assisting the RCIPS in a joint operation during the course of their duties, which is very important. Mr. Speaker, the new bill will also allow the Ombudsman to undertake the investigation and resolution of complaints made by members of the public against police, including complaints that result in the death or serious harm to a person, as just mentioned. Mr. Speaker, the Ombudsman will have the power to deal with any other matter which, whether or not is subject to a complaint, is in the opinion of the Ombudsman of such a nature that it should be so investigated because of its gravity or its exceptional circumstances or because of its public interest. So, Mr. Speaker, these are known to be own motion investigations that the Ombudsman can carry forward. The Ombudsman will not deal with grievances between police officers. Those are matters that were dealt with by the police. The Ombudsman will have the same powers as the Grand Court in respect of the attendance of witnesses and examination of witnesses. So we want to give the Ombudsman the power to carry out their duties. The bill makes provisions for a member of the public to make a written complaint against a police officer at any police station or to the office of the Ombudsman within 6 months from the date on which the alleged act took place. So again, Mr. Speaker, we have looked at this very carefully. We don't want people having to go to the office. If this incident happened in one of the districts, they can simply go to that district station, make the complaint, but know that their complaint will be handled independently of the police. The Ombudsman will then decide who investigates the complaint, whether it is the police, the Professional Standards Unit, the Office of the Ombudsman, or any other investigative body he chooses. It will depend on the complexity and seriousness of the complaint. So, Mr. Speaker, if somebody complains, I went to the police station and the officer was on the phone and didn't take my complaint in a timely manner, the Ombudsman may want to simply refer that back to the police and say, listen, this is about quality of service, it's a customer service issue, you handle it. Obviously, if it's about police brutality, then they would want to own that complaint and deal with it. So we believe that we have given the Ombudsman the flexibility that is needed to carry out their duties effectively. Mr. Speaker, the bill sets out that there are two ways to resolve a complaint, informally or formally. It is likely that minor complaints will be resolved informally, as I just said, at the police station by a senior officer of at least one rank higher than the rank of the police officer against whom the complaint is made. So if a constable is complained of, then it has to be someone that is higher than him, a sergeant or inspector, who would then deal with the complaint. Research in the United Kingdom shows that the majority of complainants typically want an apology, Mr. Speaker. That's really what they want. The opportunity to express their feelings or to stop a similar incident from happening to someone else. Most people, they just want somebody to say, sorry, we didn't deal with you in a correct manner, we won't let it happen again. So that, again, is our options available. For minor complaints, the new bill requires that a copy of the informal resolution is forwarded to the Ombudsman within 2 working days of the resolution of the complaint. Again, open and transparent. If the police are dealing with it informally, they still have to report that to the Ombudsman so that we ensure that the complaint was viewed seriously and properly addressed. The new bill provides that no reference will be made in the personal record of a police officer to a complaint resolved informally. Where the Ombudsman is of the opinion that the informal resolution was obtained as a result of a misunderstanding, a threat, or improper pressure, the Ombudsman may order a formal investigation of the complaint. A formal investigation, Mr. Speaker, will be carried out by the Ombudsman and his staff. Where the Ombudsman undertakes a formal investigation, the bill provides that notice shall be given to the Commissioner of Police, but where the investigation is in relation to the members of the Commissioner rank, your Deputy Commissioner, your Commissioner, the notice shall be given to Her Excellency the Governor. Mr. Speaker, the bill requires the investigative body to provide to the complainant and the police officer concerned an interim report within 60 days of the complaint being made. So we didn't want situations where complaints were being made and months went by and there was no update. This requires that within 60 days, the complainant is given at least an interim report so they can see exactly what's happening with their complaint. On completion of an investigation, the Ombudsman will submit a final investigative report to the complainant, the police officer against whom the complaint was made, and to the Commissioner of Police. Again, open and transparent. There's no secret as to what the Ombudsman found, which means the complainant gets a copy of it, the police officer and the Commissioner is given copies. Again, a very open and transparent process. We're talking about public confidence, Mr. Speaker. That is really what this bill is about. The new bill, or the bill, requires that the final investigative report will contain a summary of the complaint, a description of the alleged misconduct by the police officer, a summary of the investigation, information obtained from the complainant, the police officer concerned, and any witnesses, a description and analysis of any physical evidence obtained, the procedure or legal decisions made, the findings of fact, the recommendations made, if any, and the determination of the complaint. You can't be more open and transparent than that, sir. Mr. Speaker, the finding of fact from the investigation report is binding on the complainant and police officer in any related administrative or civil proceedings, including police disciplinary matters. Mr. Speaker, the bill provides that the complainant or the police officer may seek leave of the Grand Court for a judicial review of the Ombudsman determination within 28 days of the investigative report being issued. The JR is limited to issues of jurisdictions, finding of fact, and the decision as to whether the complainant was well-founded, but does not include recommendations made. Mr. Speaker, the bill requires the Commissioner of Police or his designate to review the final investigation report, and he may proceed to take disciplinary action against the police officer if he thinks fit. The Ombudsman will not recommend disciplinary action. This is a matter for the Commissioner of Police or his designate. So again, Mr. Speaker, the Ombudsman makes a determination, but it's not his job to discipline police officers. That is a matter for the Commissioner of Police, and that is being preserved here in this bill. Where the Ombudsman has made a recommendation and he is of the opinion that no adequate action has been taken by the Commissioner of Police to remedy the concern, that can be made public through this Parliament, Mr. Speaker, which is very important. Again, it calls about accountability and public confidence. Of course. Mr. Speaker, the Ombudsman will be required within 3 months after the end of each financial year to submit to the Legislative Assembly a report of the activities. Mr. Speaker, where the Ombudsman makes an investigation of his own initiative, it shall be laid before this Parliament as well. Mr. Speaker, I will be proposing just a few minor committee stage amendments that have been raised during some final consultation with the police. There's only a few of those. Mr. Speaker, in summary, the Office of the Ombudsman will have the power to deal with all public complaints against the police. It will be independent and have sufficient resources. It is anticipated that initially complaints will increase as the public will now have a mechanism and an entity to resolve the complaints. This is long overdue, Mr. Speaker, and it is something that the public has been asking for quite some time. Mr. Speaker, I want to thank the Ombudsman Project team and the many, many police officers who was consulted on this and who assisted in preparation of the bill. Everyone worked really hard on this bill, and it's for those reasons why we have, I think, a really great bill before this House, and I will ask all members of the House to support this important piece of legislation. Mr. Speaker, I thank you.
Does any other member wish to speak? Honorable member from East End.
Thank you, Mr. Speaker. Mr. Speaker, I have a few observations that I would like to get some response from the Deputy Governor upon his response to the bill. Mr. Speaker, I know there are a number of bills in this regard about the ombudsman. I don't know. My first thing that I would like the Deputy Governor to answer is, where are we going to get such a human being to cover all of these things? I understand through the grapevine that it's Commissioner Beans. Mr. Speaker, I am mindful that this position is going to be one massive undertaking. However, be that as it may, we will see who is that capable. Mr. Speaker, the Deputy Governor has said that there are a number of things to be done before this bill can come into place. Recruitment of staff, the development of policies and procedures, agree at some stage MOUs with overseas investigators, and the list goes on and the list goes on. I wonder why those things weren't started before, but more importantly, what has happened during all this period? I know the police bill was done in 2010, and the Deputy Governor emphasized that it's been 6 years and the provisions in that bill was called for a complaints section of the police department to set up a board. We know that the commissioner at the time was not overly excited about it, despite coming from a country where every street corner has a commission set up, police commission set up. Every county, every police department in England has an oversight complaints board of civilians. Madam Speaker, Mr. Speaker, I don't know what the professional standards unit is today, but the question is, what have they been doing? Where have all the complaints gone? I believe if I'm not quoting him incorrectly, he said that there are some 100 complaints annually, 10 serious, at least 10 serious. Who's been handling all of these? Nobody. Mr. Speaker, isn't it any wonder? Now the light bulb is going off in my head. For too often, we hear people calling up the radio and say they made complaint and nobody got back to them on the radio shows, Mr. Speaker. Mr. Speaker, that is a serious matter. Very serious. Recently, a friend of mine, he wasn't in trouble, but someone encroached on him, and who was a public officer, aided and abetted by the police. He went to the police station to complain about the behavior of this public officer and about the police officers that aided and abetted that public officer. And the police officers told him that he had no complaint. So may I submit to the Deputy Governor that is probably more than 100 of that nature. Maybe he or some of his people wants to pay close attention here. Because, and I may have missed it, there is nothing I see in this bill which says, which addresses that type of scenario, wherein someone goes to the police station, makes a complaint, and they are dismissed. It is assumed in this bill that the police is going to take all the complaints, and that's not true. That's not true. It is, there is. Well, if there is, I thought it was, not that I thought it was in here, I just didn't see it. There is nothing that I see in here which requires every police officer, when a complaint is made, to duly record it and pass it to this ombudsman that has oversight. Because there has been numerous occasions that I'm aware of wherein civilians complain and they're dismissed right there at the police station by them being jury and judge and saying you don't have any case to complain about. If we're talking about transparency, if we're talking about I think the deputy governor spoke of confidence in the public. Then there must be a requirement that whenever a complaint is made, regardless of how frivolous it may seem. Now, if it is determined afterwards that it's frivolous, then I understand that. I understand that quite well. People should not be making those complaints. But a police officer is in no position to determine that it's frivolous. Especially if it is against someone, some of his superiors. He cannot determine that until an investigation has been conducted. Now, the argument may follow that he can see from the initial complaint that something is wrong with him. But in the same token, the person who's making the complaint needs to be respected. You can't dismiss the person on the immediate complaint. There should be some level of that complaint taken before you can determine that it's frivolous. Speaker, Mr. Speaker, I saw Section 4 too, but there is nothing in here which addresses that. I understand the section which addresses that they may try to resolve it there. And I understand they shall take the complaint. But there are instances wherein people are dismissed without exercising that shall. Shall says that they must do it, and they must do it. But in many instances, they should be doing it now. As a matter of fact, the police law requires them to do it. But no one, and when those people complain, nothing happens. And what happens is that the confidence that the deputy governor spoke about in his presentation of developing that confidence in that relationship between the two entities, the civilian and the police department, gets further eroded. Because I know my friend, he was extremely upset that when he made the complaint against these police officers, he was told he has no case, nothing to complain about. He was complaining on trespass. They can't do that. There must be some provision. And I understand shall. But what happens when we get a complaint that they didn't do it? Mr. Speaker, I have concerns about surrounding that area of making a complaint. There are many instances, and I am sure, Mr. Speaker, this will come back to haunt us, that we will hear civilians saying they made a complaint and they were dismissed. it is going to happen. You make the complaints to the police station in your constituency, and nothing happens. I would encourage all citizens to make it direct to the overarching body. There's no need to put it here to make it a complaint to the police. Absolutely none. Who does the citizens of this country complains to now when they have a complaint against the civil servants? Do they go to the deputy governor? Do they go to the department? Do they go to junior staff in that department? No, they don't. They go direct to the complaints commissioner. Direct. You go to the police, you're going to get 2 or 3 out of 10 that is dismissed. For whatever reason, there has to be a stopgap for individuals. We have seen it happen too often where people complain against the police and nothing happens. Nothing comes of it. Why nothing comes of it? Because they protect each other. And in many instances, that's normal. And we're going to find that. So we need to move that provision away. We need to take it away from them. Mr. Speaker, and everybody's looking at me like, you really think so? Well, let me say it this way, Mr. Speaker. You really think we don't have an affinity for each other in here? As much as we argue, someone complain on one of us, there is going to be doubt immediately in our mind that that happened. So the police are no different? I mean, there are some now that might not necessarily believe that someone like me didn't do it or another one of us didn't do it, but they're going to say, but I don't believe Arden would do such a thing. That's immediate. That's the immediate reaction. Sound like you don't have much confidence. Mr. Speaker, I believe that we, as human beings, are prone to defending each other. Mr. Speaker, you know what amazes me, though, if I may digress a little bit. You know what amazes me? Is that this should have been in place since 2009. Unfortunately, there were those of us in those constitutional talks who did not believe in it. Why don't you get up and say who it was? All I'm saying is people were fearful that we were trying to take over the police department and direct the police department. I hope people now understand that that's not what it's about. Whether I support this or not in its current form, we don't need to take over the police department. Parliament needs to direct how it's managed. That's all. And I still believe that the Minister of Justice should have police department under that ministry. I still believe that. And I hope the day comes in my lifetime that I see us develop a ministry of justice, which will ensure not necessarily the management, because the day-to-day management is under military disciplines, but certainly have more say in the administration thereof. You can't expect to bring people into this country as the hierarchy of the police department, and they have never touched foot in this country hitherto. You can't expect to do that and expect it to operate without oversight. There is always a need for oversight. No interference in the discipline and the likes of the officers, but there must be oversight. Here we are putting oversight over complaints, but we don't want the premier. We want him to take responsibility for bringing that money down here and getting it approved, though. But we don't want him to have oversight as a Ministry of Justice under the Premier's office. You see how hypocritical this is? Are we noticing? Who is best suited to know, to have oversight over a police department, the security of the country? Mr. Speaker, I don't know what they're afraid of. Are they afraid we're going to start a war? We can't do that. But we can give oversight. The discipline, the reporting for civilians under the police of police misbehavior has been enshrined in Constitution since 2010. They wouldn't do it. I don't know if they doubted themselves as to whether or not there was some transparency or lack thereof, or they couldn't be fair. I don't know. Now, we're shifting that oversight for that very important aspect of relationship between those two entities and giving it to someone else. But we can't have a Minister of Security, a Minister of Justice, whichever we do. Is this the beginning? Please let me know, because that will encourage me, will give me faith in us. More faith, I hope, to come. Mr. Speaker, the other thing I'm concerned about in this bill, to give the ombudsman the power of the Grand Court. Specifically, it says not a magistrate. Well, it doesn't say that. It says the power of Grand Court. That's us putting some serious powers in the hand of one individual. That's some serious delegation of powers. Serious. The only other entity in this country that has that power happens to be right here. And we are now giving it to an ombudsman. I think maybe we can say they give them some kind of authority to summons, but, and I know the Attorney General will opine on it. I am sure he will. Speaker, I hope that no matter what I do, the government is going to do this. I hope that it works. I really hope it works. Because whilst I appreciate the governor, deputy governor saying that there is a need for something to happen, some focal point for these complaints. I do have my concerns on how some of it will be structured. I thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? If not, I'll call on the Deputy Governor, the mover, to exercise his right of reply.
Mr. Speaker, thank you very much, and I thank all members for their support. Mr. Speaker, the member from East End asked what the preparations were for the coming into effect of this bill, and why we haven't started doing some of the preparations. Mr. Speaker, the good news is that we have started and completed most of the work that has to be done. The job descriptions have been created. The procedures manual has been completed. Really what we're waiting now for is for these laws to be passed, and then we can get the ombudsman appointed and move forward. The member from East End talked about, he spent a lot of time on this particular point. What happens if the police, so a member of the public wants to complain, something has happened with them in relation to a police officer, they want to complain, they go to the police station, and the police simply doesn't take their complaint or dismisses them. Mr. Speaker, Section 4.2 of the law, of the bill, Clause 4.2 says, the person, so let me start by 4.1. A member of the public may make a complaint against a police officer, A, at any police station or at the office of the ombudsman, in a form or in writing, providing the information required by the ombudsman. Clause 4.2. The person who receives a complaint under subsection 1 shall record it and provide it to the complainant, a copy of the complaint made with an acknowledgement of receipt endorsed on the copy. So that makes it very clear that you just can't dismiss someone. You have to record it and give them a copy of the complaint. But, Mr. Speaker, the member is correct. What happens if a police officer doesn't do any of those things? So he's required to take the complaint, he's required to record it, but he simply just doesn't do those things. Obviously, the member of the public then has a right to go down to the ombudsman, and that will be a second complaint, because not only has he been, his original complaint is outstanding, but he now has a second complaint against the police officer for not taking his complaint and not complying with this bill. We thought it would be, the member questioned why we would want people to have the option of going to the police station in the various constituencies. We think that's just good flexibility. Some people may not be able to get to Georgetown if they live in East End or one of the other districts, so we want to give them that ability. But we take his point and we look at that a bit more. He talked about the powers of the Grand Court. Mr. Speaker, unless I'm wrong, that power exists right now for the Complaints Commissioner. They have the authority of a Grand Court judge. So that is not, and the Civil Service Appeals Commission has those powers. It is standard that we want to give these very serious bodies the right to be able to do their jobs effectively. So giving them that responsibility, we believe, is the right thing to do. Mr. Speaker, with those few words, I thank you.
Mr. Speaker.
Honorable member from East End.
Mr. Speaker, I don't want us to fall into the quandary we're in with the non-profit organization. We on this side have about 4 different ones of these green bill. I don't know what's going on. Before we vote on it, I think I should bring it to your attention, Mr. Speaker. 4 in this one, this was 16 December 2016. 4 in this one says the ombudsman shall not enter upon the duties of his office until the ombudsman has taken and subscribed the oath of office. I think we need to. 3 goes down in this one to subsection 8. And then 4. 4 in this one says a member of the public may make a complaint against a police officer. Yeah. Wait, hang on. That's correct. 2 different ones over here. Well, he don't get one, I get one. Pardon me? So, and then 5 in this one says there shall be paid to the ombudsman annual salary. 5 and this one says if a member of the public makes a complaint other than one.
Honorable member, we've been talking about the one with 4, 1, and 2. A number of people has referred to that through the debate. I don't know if the deputy governor has any difference. The question is that a bill shortly entitled the Police Complaints by the Public Bill 2016 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no.
No.
The ayes have it.
Can we have a division, please?
Madam Clerk.
Always stop in progress.
Honorable Alden McLaughlin.
Aye.
Honorable Moses Kirkconnell.
Aye.
Honorable Kurt Tibbetts.
Aye.
Honorable Osmond Bodden. Honorable Wayne Panton.
Aye.
Honorable Marco Archer.
Aye.
Honorable Tara Rivers.
Aye.
Mr. Roy McTaggart.
Aye.
Mr. Joseph Hugh.
Aye.
Honorable McKeeva Bush.
No.
Mr. Barney Bush. No. Captain Eugene Ebanks.
No.
Mr. Alva Saku.
No.
Mr. Winston Conley,
No.
Mr. Ezra Miller, Mr. Arden McLean.
No.
Honorable
I recline. The results of the vote is 8 ayes, 7 noes. The bill has succeeded. I would ask that the House be suspended for 10 minutes. We'll be back at 20 minutes to 10.